Hi, my name is Adam Cordover, and I'm a collaborative attorney here in Tampa Bay. I hear clients ask all the time, well, why can't I just go in front of the judge? Of course, if they hear what I have to say, then the judge is obviously going to rule in my favor. Well, we've got some fantastic judges here in Hillsborough, Pinellas, and surrounding counties, but the truth is that they have limited time, limited resources, limited outcomes which they can provide. Maybe one way to demonstrate this is with a piece of paper. Okay, let's say that this piece of paper represents your entire life story, and you come into my office. And obviously, when you come into my office and tell me what's been going on in your marriage, you can't really tell me your entire life story. There's only a certain amount that you can tell. And let's say that you can tell me about a quarter of your life story. Now, that's probably not realistic in and of itself, but let's just say that that's what you can tell me. And the truth is that in the case of most traditional divorce lawyers, they won't necessarily be hearing that quarter of the life story that you tell them. They may be hearing a quarter of it and filtering in their mind what may actually be relevant. So the entire thing, 100% of your life story may be relevant to you, but to the lawyer, maybe only a quarter of what you actually say is relevant. But then the attorney needs to figure out what is the information, the ideas that a judge is going to find relevant. And so because the time that you can get in front of a judge is even more limited than the time that you can get in front of your own lawyer, the attorney needs to minimize that information. So it may be only a quarter of that information is important to the judge. But the truth is that what an attorney thinks is important isn't always what the judge thinks is important. So they may only listen to a quarter of what that attorney says. And so obviously at this point, we can't even fold this piece of paper, your life story, any further. And of course, ultimately when a judge writes a final judgment, they may or may not remember everything that was said of that quarter that they found important. So that final judgment is going to be based on that. So who knows? I mean, maybe if you go in front of a judge will think that your story is incredible and that you should get everything that you want. But again, based on this, the judge is only going to be hearing a small amount of the information that you have available in order for a judge to make a ruling. So instead of this, what we suggest is let's take it out of the hands of the judge. Let's enter into a collaborative process. To learn more about the collaborative family law process, feel free to go to my website, familydiplomacy.com. Talk to you soon.